So the plaintiffs in the Miller v. Bonta California assault weapons ban case have filed a brief to the Supreme Court arguing that the court should hear an assault weapons ban case. So let's talk about this. But real quick before we jump into this video, if you think a ban on AR-15 rifles is unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Acre Gold. Acre Gold helps you acquire physical gold bars through a monthly membership. You pay each month, and once you reach the price of the gold bars, they actually discreetly ship them to your house. Acre lets you invest in physical gold without the full price of the gold coming out of your pocket all at once. So if you're interested, head on over to Acre Gold using the link down in the details section, and thank you again Acre Gold for sponsoring this video. So like I said in the intro, the plaintiffs in the Miller v. Bonta case, which challenged California's ban on so-called assault weapons, have joined together to push the Supreme Court to finally strike down assault weapons bans in a case that is currently up for Supreme Court review. The case we are going to be talking about in this video is Bonta v. Frosch. This case is asking the United States Supreme Court to strike down Maryland's unconstitutional ban on so-called assault weapons. As you would expect, if the Supreme Court takes up this issue, it would have major implications not just for the state of Maryland, but also other restrictive states that have assault weapons bans like the state of California. That is why the plaintiffs in the Miller, California case have filed an amicus brief supporting the Supreme Court actually hearing this issue. Now for some quick background on this case, the state of Maryland identifies certain rifles as so-called assault weapons. Maryland bans the sale, transfer, possession of semi-automatic centerfire rifles with detachable magazines and two offending features, like a folding stock, a grenade launcher, a flash suppressor, and other things as well. Now, Maryland does have some workarounds, like the heavy barreled rifle rule, but in reality, there are still an assault weapon ban on the books, and it's likely only a matter of time before the state decides to plug that hole. This case arises out of a challenge to that Maryland ban. In this case, the plaintiffs argued that a prior decision by the Fourth Circuit in the case Colby was incorrect. In that case, an en banc panel found that these rifles are outside the ambit or protection of the Second Amendment because they are useful in military service. Now, in support of this case, the plaintiffs in Miller filed an amicus brief arguing further why this issue needs to be heard. In their brief, they argue at issue is Maryland's categorical ban on common semi-automatic rifles, dubiously deemed assault weapons. Like California's Assault Weapons Control Act, Maryland bans so-called assault weapons based on their characteristics such as magazine capacity, detachable magazines, folding stocks, flare launchers, and flash suppressors. Maryland's categorical prohibition was upheld en banc by the Fourth Circuit in Colby v. Hogan on the inaccurate assertion that commercial, commonly owned AR-15 rifles were deemed sufficiently like M16 rifles, i.e. weapons that are most useful in military service, to take them outside the protections of the Second Amendment. The Fourth Circuit's novel standard of review is another addition to the number of lower federal court cases that have affirmatively rejected the clear categorical analysis prescribed by the court in District of Columbia v. Heller and McDonald v. the City of Chicago. In sharp contrast, the court in Amici's case, Miller v. Bonta, applied proper review standard using the hardware test and asking the simple question, does the law ban a firearm commonly owned by law-abiding citizens for lawful purposes? This test draws a distinction between commonly owned arms for lawful purposes and arms that are both dangerous and unusual, such as arms solely useful for military purposes, i.e. grenades and missiles. If the law bans commonly owned arms, the law is unconstitutional. End of analysis. So there you have the plaintiffs in Miller arguing in their brief to the Supreme Court that first, the useful in military test that the Fourth Circuit used in Colby and in that decision is just another incorrect type of analysis that a lower court has decided to use instead of what the Supreme Court actually established in Heller. Also, they point to the fact that the AR-15 is used by law-abiding citizens for lawful purposes, and these rifles are not dangerous and unusual. Therefore, an outright ban on commonly known arms should be found unconstitutional, and that should be the end of the test. Now, the three main arguments the plaintiffs put forward in their brief for why the Supreme Court actually needs to grant review, in this case, Bonta v. Frosch, was first, unlike the Fourth Circuit, the District Court in Miller v. Bonta did use the correct Heller test. 2, modern rifles are not dangerous and unusual arms, but are ideal for self-defense. And 3, because modern rifles like these AR-15s, are ideal for militia service. In the first section, they argued that the District Court in Duncan established what was coined to be the hardware test, which was also used in Miller in the context of bans on so-called assault weapons. Under the hardware test, the court asks, is the firearm hardware commonly owned? Is the hardware commonly owned by law-abiding citizens? Is the hardware owned by those citizens for lawful purposes? If the answers are yes, this test is over. The hardware is then protected. The plaintiffs go on to say in their brief that once it is determined that the Second Amendment applies to a particular type of arm, it is unconstitutional for the government to ban it. This flows directly from Heller, which categorically struck down the District of Columbia's handgun ban. So the only real question is whether these arms, i.e. AR-15 style rifles, are commonly owned by law-abiding citizens for lawful purposes. In the brief, the Miller plaintiffs first point to the overwhelming numerical proof that these are commonly owned for lawful purposes by law-abiding citizens across the nation. Evidence that was presented in the Miller case before the district court is also pointed to again here in this brief. And there in Miller, they found that in 2018 alone, 1.9 million of these rifles were imported or made in the US, and they were imported or made for sale. Also, evidence shows that over the last 30 years, over 20 million of these rifles were actually made or imported into the US for sale. And even worse for states like California and Maryland is the fact that the Supreme Court in the Caetano stun gun case found that as few as 200,000 stun guns owned nationwide in the US was enough to show common ownership, and therefore those arms were protected and provided constitutional protections. Therefore, there is no way that hundreds of millions of AR-15s owned and possessed across the US would not be afforded the same amount of protections as 200,000 stun guns. They then point to the fact that 44 states do not ban these semi-automatic rifles. Instead, the rarity is the handful of states that actually do ban these rifles. On that basis alone, the majority of the US actually treats these as protected arms. They then move on to their second main argument, which is that these rifles are ideal for self-defense. They argue that standard characteristics that enhance accuracy, control, and safety should be encouraged, not banned. Rather than promoting safer firearm handling, Maryland's regulatory scheme prevents firearms users from maximizing the safe and controlled use of common semi-automatic firearms. Unquestionably, the characteristics that trigger prohibition, in fact, improve the safe and controlled use of such firearms. So the state is not making anything safer, instead they're actually making things worse by banning important characteristics of these firearms. Finally, in their last argument, the plaintiffs argue that these arms are well suited for use in the militia. Now, I want to stop here real quick and say that I love that they actually added in this argument. This is something that some attorneys shy away from and don't use, but this is an important aspect of our fundamental rights. In this section, they quote Judge Benitez in the Miller case when he said, "In this case, the evidence overwhelmingly shows that AR-15 platform rifles are ideal for use in both the citizens' militia and a state-organized militia. Quite apart from its practicality as a peacekeeping arm for home defense, a modern rifle can also be used for war." The Colby analysis said that if a firearm is useful in military service, then it can be banned. However, our Second Amendment recognizes not just a right to self-defense, but also a right to defend ourselves from tyranny, both foreign and domestic. To those aims, an arms or a firearm useful for the militia and use in military to defend ourselves, both foreign and domestic, are therefore protected. So those are the three main arguments made by the Miller plaintiffs in support of why the Supreme Court should actually take up this Bianchi v. Frosch, Maryland ban on so-called assault weapons. This was one of those briefs that was really enjoyable for me to actually read because it hits on a lot of important aspects of what a ban like this actually does. If you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and want to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I cannot thank you guys enough for everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you guys so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget to stay with Built Bar Arms Scholars and stay we maintain Arms Scholars.